Chris Enright. I'm a retired law academic. I specialised in skills, and I want to talk to you today really about some reforms to the judicial system based on some of the work I've done in skills. And it's an area that tends to have been a bit neglected. Can I start by a couple of comments that at the moment law schools don't seem terribly keen on legal skills. It's something that just seems to be absent from the legal mindset, and it's perhaps something that should be changed. Much of what I'm going to do today centres on a model for litigation which is set out in a diagrammatical form on page 1. I'd just like to take you through that. It's sort of self-explanatory, but if you have to take it in initially, it might balk you a little bit, so I can just say a few things that will settle you on that. This is litigation involving a dispute of facts. You'll see in the first column it's law, and that of course is the cause of action of the plaintiff. It divides into elements, element 1, element 2, element n, and just by way of refresher from your mathematics, n is the standard designation for however many there are on a particular occasion. So we go to the end of the list of elements. If you look to the middle column, it's got facts. The point is every element is saying to the plaintiff, if you want to win this case, you have to prove this type of fact. And so fact 1 is the fact to match element 1, and the evidence column is fairly obviously if a fact is in dispute, it needs to be proved by evidence. If you look again to the first column, and you'll see underneath element N is an arrow to consequences. The point is if you've done all that's above, then the consequences follow in terms of a remedy. There may be more than one consequence, or a consequence such as damage may have parts. Now, in order to get a consequence, you sometimes need facts and evidence. I've used some rather clumsy labels there, con fact and con evidence, but I didn't want to repeat fact and evidence above for fear of confusing you. So that's the model. What I now want to do is to illustrate the use of it, including some reform proposals. The first thing is, it's a good way of teaching newly trained, newly graduated law students about how to prepare and organise a case. It sets out a framework and it says, well, this is what you have to look for, identify the cause of action, look for the facts, look for the evidence. And it also becomes a system for organising files afterwards. That's the first one. The second one, it's useful in pleading. Now, I'll tell you a story that's not true. That comes from being a lawyer. A public hospital comes out and says, look, we've got doctors, they're fantastic at treating patients, but guess what? We've got a teensy-weensy problem. We don't know how to diagnose, but apart from that, we're utterly fantastic. Now, that might seem a bit far-fetched, but let me take you to the Australian Law Reform Commission's inquiry into the justice system in about 2001. They mentioned pleadings, and basically they said pleadings are a shambles. And having said that, they didn't proceed either to explore systems of pleadings, how you might improve it, or make a recommendation at the end that something should be done. Now that's virtually the equivalent of the doctors saying, we don't know how to diagnose a case, because a case is all about settling issues. If you haven't defined the issues, you can't get on with it. Now, this model, I believe, would lend itself to a very simple system of pleading. If I can take you back to the model, this is what I'd suggest. If you look at the first column, law, the first thing the plaintiff would file, and I must mention in putting these ideas forward, I'm just saying, look, here's an idea to consider. I don't believe I've wrapped up every problem and every issue, but something to start the ball rolling. You indicate the elements and consequences of the cause of action. Then column 2 is represented by the fact that you do, as I think plaintiffs now do, you file a statement of facts that includes your material facts. And then you do something that I don't think they do now, and this is the missing link, and it's dead simple. You go through each element one at a time and you indicate the fact that satisfies that element. So let's say you're doing trespass to land, which is the only tort I remember. One element, guess what, is there's a piece of land. So you've had element 1, land, law. The legal requirement is there is a piece of land. Fact, the piece of land in this case is the land at 17 High Street, Branxton. Now that might sound mundane, but you have now locked the plaintiff in to saying what the material facts are. Now, guess what? When the defendant comes to plead, they really don't have anywhere to run and they don't have anywhere to hide. They either have to agree or disagree, and if they disagree, they've probably got to indicate why they're disagreeing or their case is accordingly weakened. So on the surface anyway, this is defining the issues early on, simply, easily, with low costs and with pinpoint accuracy. That's the benefit I put forward to you. The next item is discovery, which is currently a goldmine for lawyers. Now let's consider how they go about discovery, and I'm relying on second-hand reports there. They go along and they say, give us all your documents. So what they're saying is, give us the haystack and we will search for the needle. And guess what? The search for the needle consumes a lot of time, it consumes a lot of resources and raises expenses. I'm saying go about it another way and go back to the system of pleading. You've identified the issue. So what you do is you organise an evidence conference, you put the defendant under a duty to disclose, and I think the audi alteram partem rule of natural justice would probably impose that duty anyway, if not enact a statutory duty of disclosure. And at the conference, the plaintiff said, look, this is our issue. These are the types of documents we need. Tell us what you've got. And then when they've identified them, you hand them over. If they're not sufficient, you go back again to clarify. But the short point is you are not asking for the haystack and searching for the needle. You're asking for the needle. The next thing is limited scope legal aid. If you go back to the model, you can see how simple it makes the structure of litigation based on a dispute of fact. And one of the options would be to set up a legal aid system using recently graduated lawyers, or at least lawyers who wanted litigation training. And what you would do is you'd train them in interviewing and you'd use that model to say, all right, identify the cause of action, and they might need some guidance on that, and this would all be done under supervision. Get the facts, get the evidence and prepare their case in writing. Now, if you're short of legal aid funds, one of the options is, instead of sending a trained advocate in to go to court, come out of court, go back to court and go out of court, etc., what you do is you submit the case in writing, and particularly if the court will allow evidence to be given by written statement. So you've dramatically lowered the input of legal aid, and by using newly graduated lawyers, a trick borrowed from the medical practitioner, you've lowered the cost of labour. I might mention that I've spoken to a law school that is interested in taking up that idea, so if anything more happens, it will come out. The final thing is writing the text of the judgment, and I'm emphasising the text. If you think of a judgment, there are really two aspects. There's the text of the facts, and then there's the decision making to decide which facts are true and which facts are not. Now, if the parties are submitting statements of facts and they do it in electronic form, it's an easy matter to blend those into one account of the facts so it flows so coherently, and that becomes a large amount of the text of the judgment. All that the judge, not all of it, I'm not trying to belittle it, but what the judge then has to do is to go through and look at the issues of facts and determine them. And I might say from my work on legal skills, unfortunately there's not a lot of science in it, because neuroscience isn't advanced to the stage where we can tell what's happening. They simply have to use their best in human terms. So in other words, it aids in writing the judgment. Well, that's all I have to say.